Hello friends, in this video we are going to study about the fundamental rights. In this video we study article 32, 33 and 34, 35. Article 32 is the most important article. It is about the constitutional remedies. So till now we have seen that the Indian Constitution provides number of fundamental rights in different areas for the empowerment and enrichment of individual self. So what is the guarantee and how we can secure if such fundamental rights is not given? In that case, where the individual or the citizen will go? In that case, this article is the most important article, not the I would say the most important. We can say that it is like the base, because if this is the pillar, this is a box and it need to be stand somewhere, and this small pyramid is able to balance the whole. So the small pyramid is this article. And so now we see it says that one individual can move to the Supreme Court by appropriate proceeding for the enforcement of rights conferred by this part guaranteed. So on Supreme Court shall have the power to issue direction or the order or the writs, including the writs in nature of habeas corpus, mandamus, prohibition, qua warranto, certiorari, whichever may be appropriate, the enforcement of any law conferred by this part. We'll discuss about these different writs in the separate video. Without prejudice to the power conferred by the Supreme Court, in clause 1 and 2, Parliament may by law empower any other court. Okay, any other court can also exercise within the local limits of its jurisdictions all or any of the power exercisable by the Supreme Court under clause 2. So whatever the power Supreme Court has, so Parliament also can give this power, because it's not that every time the citizen will go directly to the Supreme Court, because Supreme Court it can go, because but it individual can getting the similar solution from a local court also, and in the lesser time, then it's beneficial for the citizen to go to this court rather than moving to the Supreme Court. And now the right guaranteed by this article shall not be suspended except otherwise provided by the Supreme Court. So whatever rights citizen is having, they cannot be suspended except in case of it is provided by the Indian Constitution. Now the Article 33 says that Parliament may by law determine to what extent the right conferred by this part shall applicable to certain uh, services. For example, member of armed forces, member of forces for maintaining a public order, person employed in any bureau or any organization established in any state for the purpose of intelligence, person employed in connections the telecommunication system set up for the purpose of any force or the bureau or the organization. So because these forces are very important for our country, so there is need to be maintained some kind of uh, rules and the regulation to run this organization. If anything happens to this organization, then there are chances that it is going to influence the public law and order, or the uh, different situations in our country getting influenced by such actions. So there is a need to maintain a discipline or unity and integrity of our country, and these organizations have to function in a certain way. So therefore, Parliament will decide that up to what extent they are provided with their fundamental rights by this article. Now they are saying that notwithstanding anything in the foregoing provision of this part, Parliament may by law indemnify any person in the service of the union or a state or any other person in respect to any act done by him in connection with the maintenance or restoration of order in any area within the territory of India where the martial law was in force, or validate a sentence passed, or the punishment inflicted, or forfeited, ordered, or other act done under the martial law in that case. So this provision says that if suppose this is an area where the situation is very poor, and there is a martial law. Martial law is a law, emergency law, which is to deal with the emergency situations. If suppose there is a poor law and order situations, and in that case, any public servant made or attempted to do something to restore the public order, in that case, he or she need to take certain actions which take away certain fundamental rights of the people, and this law protect these public servants to for their actions to uh, restore the law and order situations in that area. Now, Article 35 says that notwithstanding anything in this Constitution, law shall have the legislature of a state shall not have power to make laws with respect to any of the matter mentioned in three of the Article 16 and Article 33, 34 may be provided by law by the Parliament, and prescribing punishment for the act and the declare. So this provision says that Parliament have the power, not the state legislature have the power to make law, any law related to the provisions of Article 16, Article 32 related to giving power to any court equivalent to the power to the any court to exercise the power conferred by Article 22 to the Supreme Court. So, and if anything, or it's about the restricting fundamental rights for any member of the services, then it is done by the Parliament, not by any state legislature. And in case if it is in Article 34, if Parliament in indemnifying any government servant, then it is done. It should be done by the Parliament, not by the state legislature when the martial law is in force. So Parliament have the power to make laws, or it related to any punishment given in the for human trafficking or for untouchability, and it is the Parliament have the law to come after the commencement of this to make laws for prescribing the punishment in above acts. So it is like Parliament. So we can say that this Article 35 states that Parliament has the power to make laws in certain areas, despite that is falls under the state list. So, even Parliament can make laws. And thank you for watching these videos.